Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Justice S.V.N. Bhatti of the Supreme Court today recused from hearing the petition filed by Chandrababu Naidu, former Andhra Pradesh Chief Minister, seeking to quash the criminal proceedings against him in connection with a multi-crore skill development scam in the state. Naidu has filed an SLP challenging an order of the Andhra Pradesh High Court last week, which dismissed his plea to quash the FIR in connection with the scam case. Today, the matter was listed before a bench comprising Justices Sanjeev Khanna and S.V.N. Bhatti, who hails from Andhra Pradesh. After this, senior advocate Siddharth Luthra, appearing for Naidu, mentioned the matter before the Chief Justice of India for urgent listing. The CJI agreed to list the matter on 3rd October, but he further orally told Naidu's lawyer that the court will not restrain the trial judge from hearing the application filed by Andhra Pradesh CID for police custody of Naidu in the meantime. You are aware that a petition has been filed by the Delhi government challenging the Government of NCT Delhi Amendment Act of 2023, which gives overriding powers to the Delhi Lieutenant Governor over the control of civil servants. Senior advocate Dr. Abhishek Manu Singhvi today orally mentioned the matter, requesting to urgently list the petition. Underlining the urgency, the senior advocate said that the civil servants were not following orders. But the CJI cited difficulties in hearing the matter soon, as 2 7-bench hearings are scheduled to happen in the coming weeks. Further, Advocate Sanjay Jain, appearing for the Delhi Lieutenant Governor, stated that the questions framed initially required to be changed. Accordingly, the CJI asked both the counsel to decide the issues and submit the common compilation to the court. Without giving any specific date, the CJI said that he would look at the matter. The Supreme Court has set aside an interim order passed by Calcutta High Court in July 2022, whereby it allowed medical students to participate in counselling sessions for the admission process in August 2022 based upon the results of NEET 2019. This was for the admission to the MBBS course in West Bengal University of Health Sciences. This case revolved around 3 petitioners who appeared in NEET UG 2019. The petitioners were ranked at 3,14,773, 3,25,058 and rank 6,64,781 respectively, with a percentile of 77.5, 76.9 and 52.68 respectively. All 3 applied for the economically weaker section eligibility certificate from the appropriate authority in July 2019. But there was a delay in the issuance of the certificate. When they were appearing in round 2 counselling of the selection process in West Bengal University of Health Sciences, they were informed that they were not eligible to appear since the EWS certificates had not been issued to them. The EWS certificates finally reached them in August 2019, but by this time, round 2 counselling had already been completed. They approached the Calcutta High Court, and the single bench directed the registrar in charge of the university to allow the petitioners to appear in the mop-up counselling for the West Bengal undergraduate MBBS state quota seats of 2019. The registrar in charge appealed against the decision before the division bench. The division bench in July last year said that the petitioner should be at least allowed to participate in the counselling session for the admission process in August 2022. But the Supreme Court, after hearing the appeal, has now set aside this order. The bench, comprising Justices Vikram Nath and Asanuddin Amanullah, set it aside on 2 grounds. First, that 2019 NEET results could not have been the basis for allowing counselling in year 2022. And second, that an interim order could not have granted such direction. And now an update on the Sanatana Dharma row, or the remarks made by Tamil Nadu Minister and DMK leader Udayanithi Stalin over his controversial remarks, where he compared Sanatana Dharma to diseases like malaria and dengue and advocated for its elimination due to rooted caste system and historical discrimination. Today, the Supreme Court tagged a petition seeking registration of FIR against him over his remarks with another petition in which the court issued notice last week. The bench of Justices Aniruddha Bose and Bela M. Trivedi was hearing a writ petition filed by a Delhi-based lawyer, Vineet Jindal, alleging that Udayanidhi's comments constituted hate speech and urged the court to direct criminal proceedings to be initiated against him for hurting religious sentiments. Jindal has further questioned as to why the Tamil Nadu police had not complied with the Supreme Court's direction to initiate suo motu criminal proceedings against hate speech and called for contempt action against both the Delhi and Chennai police. Tamil Nadu Additional Advocate General Amit Anand Tiwari questioned the need for another petition when the court had agreed to hear a similar plea already. The court then clarified that it would not be issuing notice in this petition but was merely tagging it with the other plea. In another update, the Supreme Court today admitted the appeal by National Investigation Agency challenging the bail granted to tribal rights activist Mahesh Raut in the Bhima Koregaon case over alleged Maoist links. Raut has been behind bars since his arrest in June 2018. Last week, the Bombay High Court had granted him bail. Though the High Court noted that there was no prima facie evidence to attract the offences under UAPA, but it had stayed the bail for a week at the request of NIA. Now the NIA has approached the Supreme Court in an SLP challenging the bail granted. Today, Additional Solicitor General S.V. Raju, appearing for NIA, said that there were incriminating letters which show Raut's links with the proscribed Maoist outfits and also requested for the stay to be extended. Senior Advocate Mihir Desai, appearing for Raut, objected to this by saying that he had been in jail for over 5.5 years now, and that his case was covered by the Supreme Court's recent judgment in the Vernon Gonzalez case, by which bail was granted to two co-accused in the case, that is Vernon and Arun Ferreira. But the bench, comprising Justices Aniruddha Bose and Bela M. Trivedi, while posting the matter to 5th October, further extended the stay already granted by Bombay High Court until then. The next update is regarding the TVF web series College Romance. Earlier this year, the Delhi High Court had ruled that the language used in the web series does not pass moral decency community test of a common man and transgresses into the area of obscenity. The High Court had said that the use of vulgar language in public domain and social media platforms which are open to children of tender age needs to be taken seriously. The High Court was hearing petitions moved by TVF Media Labs Private Limited, casting director of the web series, and its lead actors against the orders passed by the Sessions Court for registration of FIR against them. The High Court had upheld the registration of FIR under Section 67 and 67A of the IT Act. The makers of the web series then approached the Supreme Court against this order. The Apex Court has now said that it will look into whether Section 67A of the IT Act would apply to profane language or not. For your information, let me tell you, this section prescribes punishment for a person who publishes or transmits in electronic form material containing sexually explicit act or conduct. During the hearing, Senior Advocate Mukul Rohtaki, appearing for the makers, argued that no offence is made out under Section 67A as it would not apply to profane language. He also said that the makers were portraying how youngsters speak in college through slangs, and it was a part of life. But the bench of Justices A.S. Bopanna and Justice M.M. Sondaresh expressed its reservations about the same. The court said, in act and conduct, act had a broader sense, and a technical interpretation that act means only physical act could not be given. The matter has been kept for further hearing on 31st October. Stay tuned with us. The Supreme Court today heard an SLP filed by Nipun Cherian, the president of political party V for Kochi, against the order of Kerala High Court that sentenced him to 4 months imprisonment. The High Court had sentenced him in the suo motu contempt case for his statements against a sitting judge of the High Court. The contempt case pertains to a speech made by Cherian before farmers, fishermen and representatives of the local people of Chelanam, where he had levelled allegations of corruption against a sitting judge of the High Court. His plea states that the allegations of corruption were made in good faith and with reasons. He further states that the protection accorded to a judge for judicial work cannot be extended to any executive work that he or she may undertake using the office of the judge, as in this matter. The Supreme Court bench of Justice A.S. Bopanna and Justice Sudhanshu Dholia pointed out that Cherian had a statutory remedy of filing appeal to the Supreme Court and that the SLP was not the proper remedy. He was then permitted to convert the SLP to an appeal, and the matter was posted to 3rd October for further hearing. And lastly, an update from the Delhi High Court on the decision of Union Government to reduce cutoff for postgraduate medical college admissions through NEET-PG 2023 exam as 0 percentile. Last week, MCC, that is the Medical Counselling Committee, announced the decision of Ministry of Health and Family Welfare to reduce the NEET-PG qualifying percentile. This was to allow all medical graduates to participate in super speciality course admissions, aiming to address vacant PG medical seats. A plea before the Delhi High Court has been moved by 3 MBBS doctors who took the NEET-PG exam on 5th March and were participating in the counselling process. The plea states that by reducing the eligibility criteria to 0 percentile, that is minus 40 marks, the very purpose of conducting NEET-PG exam stands defeated. It also fades away the entire purpose of a national eligibility cum entrance test if the quotient of eligibility itself is diluted. That the impugned order is prejudicial to the candidates who had opted out of the second round of counselling process, as it seeks to operate in retrospect. Candidates had opted out of second round hoping for a better seat in the mop-up round that used to be held each year. However, the conversion of seats in the proposed third round is different and substantially less than the former mop-up round. The Delhi High Court has issued notice on the plea today. Justice Purushendra Kumar Kaurav sought response of the Union Ministry of Health and Family Welfare, National Board of Examination and Medical Counselling Committee. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.